Good morning and welcome to another session of oral arguments. We have one case this morning, and that's JAGNANAN versus PUBLIX. Before we proceed with that, let me introduce the other judges. Judge Evander is to my right, and he is on our court, originally from the Brevard County Circuit Court. And to my left is Jennifer Taylor, who is sitting with us today as an associate judge. She is currently a circuit judge down in Brevard County. Just let me know how much you want in terms of rebuttal. Typically I set it for 5 minutes. If you want, okay, that's fine. If you're not familiar with the clocks here, what it shows is your remaining time, and when it turns yellow, that's your end of your rebuttal time. So anytime you're ready to go.
Thank you, Your Honor. May it please the Court. First, my name is Daniel Ostendorf. I'm with Party and Rodriguez, and I represent the appellant in this case, Ms. KHEOLIE JAGNANAN. I'm sure the Court has read the briefs. This case involves a slip and fall that occurred at Publix on December the 4th of 2013. The allegations in the complaint are very simple. My client went to the store, she shopped, she was going through a checkout register aisle, and she slipped and fell on what turned out to be water. The evidence in this case showed that at the time of this incident, there were 3 Publix employees who were on the aisle working at the time of this particular incident. In fact, the evidence is that one of those employees, a Jarvis Ramirez, had walked up and down the aisle in the exact area where the fall took place within a minute before the fall actually occurred. Under these set of facts and circumstances, we filed suit. The case proceeded through the discovery phase, and obviously what led us to this court is that the defendant moved for summary judgment, in this case Publix, the appellee, and after hearing argument, the trial court went ahead and granted the motion for summary judgment that had been filed by Publix. In that motion, Publix had argued that we failed to carry our burden of proof under the statutory prerequisite under 7680755 because we did not show actual or constructive notice that Publix was aware of the transitory substance was on the floor. It's our contention in this particular appeal that the trial court committed reversible error by granting the motion for summary judgment because there are genuine issues of material fact that would preclude entry of that particular motion.
You agree there was no actual notice by Publix?
We stipulated that, Your Honor. Right, so this case was premised upon, both at the summary judgment and here on appeal, exclusively on the fact that Publix was on constructive notice of this case, and that at a minimum, there are material issues of fact which would require a jury to determine whether or not the facts and circumstances of this case should warrant liability on behalf of Publix.
Now, if a Publix employee walked down that aisle 1 minute before and there's no other evidence, does that suggest either that the employee missed it or that the water can be located there within that 1 minute?
What the evidence is, Your Honor, is that he wasn't just on the aisle a minute before. He was actually working at this particular register for a period of approximately 12 minutes. He was not only doing the checkout portion of it, running the register, he was also bagging groceries. I asked him specifically in his deposition is that if you're standing where you are bagging these groceries, Mr. Ramirez, do you have a clear line of sight to the area where my client slipped and fell? His answer was a definitive yes.
So there's 2 possibilities from that. Would you agree? One is, although it was visible, he didn't see it, or 2, it happened after, in the last minute that the water got there.
Agreed, Your Honor. It could have happened either while he was standing there bagging the groceries or while he was walking up and down the aisle. But in any event, he has the opportunity to look down and see it. There's no evidence that anyone came into the aisle between the time that he walked up and down it and my client. Okay? And so what the purpose of the statute is to say that if you're going to hold Publix responsible for the slip and fall incident, hold them responsible for any negligence, you have to show they're on constructive notice under the 2010 statute. So the question then begs is how do you prove constructive notice in a case like this? We stipulate that there's no evidence of the amount of time that was on the floor. But the key question here is who was there? What could they have seen if they had exercised reasonable care? And that's what the jury's supposed to decide.
But not under the statute, though. Under the statute, if it applies, and I know you want to argue that it doesn't, under the statute, you either have to prove that it was there for a certain length of time, which you can't do by any direct evidence here, or that it occurred with regularity, therefore it was foreseeable. You're not arguing that it occurred regularly at that location, so...
We're not going into the second prong of the statute at all, Your Honor. This is purely a constructive notice case that this particular circumstance, because of where it happened, how it happened, and who was there, that this is sufficient to establish by circumstantial evidence that constructive notice could be placed on Publix for them to be held responsible for this. Let's distinguish the facts of this case.
Well, let me ask you this.
Sure.
You're standing right now behind the podium, so theoretically you could see the carpet, all the way in that corner, all the way over there, etc. So are you, because you're there, do you have constructive knowledge of anything that might be on any piece of the carpet that's visible to you?
I think that's kind of a loaded question in the sense that I don't work here.
Okay.
I'm simply a business invitee of this particular
Okay,
court.
but I'm just
like
talking
your client.
about from a not the legal aspect, but the practical aspect of it. So regardless of whether you're looking there or looking there, are you saying that every employee would have an obligation to be, pretty much at all times, be responsible for anything that's visible?
Not be responsible for anything that happens, Your Honor, but they're responsible for conducting themselves while they're working in an appropriate and a reasonable manner. And so, unlike any of us in this courtroom, when we go to Publix, we're shoppers. We're there to look at groceries, buy things, look at shelves as we go by, look for sales, look for
But
things.
if you're working on a cash register, you're focused on running up the correct amount of money for the items being purchased.
You're focused on that. You're also watching the customers come in. But if you're working there as a bagger, you're assisting the customers. And in this particular case, he's not only there as a bagger, he's there as a supervisor. That's what Mr. Ramirez's testimony is. And he's actually going up and down this particular aisle. I want to point out...
Right, but the purpose of my question was, there really is a difference between what people look at and what's within their range. I mean, people tend to focus...
There can be, but you have to all place this in context. If under the context is if you're there, you're a supervisor, you're working at Publix, you're going up and down this aisle, you're looking up and down this aisle for a 12-minute period before my client slip and fall, and then in fact you walk up and down it. You're not there as a customer. Part of your job is to perceive potential hazards that may endanger your customers. That's what you're there to
I'm
do.
sorry I missed you putting the eggs in your bag because I was busy looking over there and I threw them on the floor. I mean, that's what Judge Evander's getting at. I understand there's definitely a difference between what a customer's looking for. They're looking for to buy the eggs and to pay for the eggs. But, somebody who's bagging the groceries is looking to get this product into the bag. The person who's there at the counter is scanning them. And, you've got these people saying, yes, we were there, we didn't see anything. Your client, when she came along, her testimony that everybody believes and takes for granted is, she didn't see it, obviously she wouldn't have stepped in it.
Well, to follow up to Judge Evander's point, let's bring this back to the real world. What is the likelihood that the Publix employees are going to stand there and say, yeah, you're right, Mr. Ostendorf, I was there and I looked down that aisle and I did see a puddle of water, but I just didn't feel like dealing with it, so I just let your client walk right into it. For practical purposes, that's not the kind of testimony that in the thousands of cases, slip and fall cases I've had, you're going to hear. It's simply not going to happen, whether it's Publix, whether it's Walmart, Winn-Dixie, or
So you
any other
say every
store.
employee is a liar?
I'm not suggesting he's a liar, but in this particular case, actually, a jury could determine that they don't want to believe him, because in this case, Mr. Ramirez specifically denied that he cleaned up anything, and that testimony is expressly refuted by his supervisor, Kayla Coolidge, which is also part of your record. Because immediately after my client's slip and fall, he went and grabbed a mop, and he mopped up the area, and his statement to her, which is part of the record, is he cleaned something up. His deposition testimony is, I just mopped it because it was a precautionary matter. Now, why that matters is because is a jury could disbelieve him. They could believe that he lacks credibility, that his statement that there was nothing there, that he didn't see anything.
Well, the only
before
issue
that.
of fact there would be whether or not there was something on the floor by that particular bit of evidence.
The issue there is that the jury could disbelieve his testimony, completely set it aside and say, listen, he's not being truthful with us, and in fact, because of his line of sight, because of the fact that he went up and down that aisle, because he was there for 12 minutes and clearly could see it, if he had looked, the jury could find, in fact, that Publix is on constructive notice of the substance that's on the floor.
But you have no idea still, I mean, was there nobody coming by in 12 minutes?
There were other customers that came in and out of the aisle within the 12 minutes, but what I'm talking about is...
When was it put down that he would have had a chance to see it?
He walked up and down the aisle within
No.
a minute before the fall.
What gap of time was there when it could have been there that he didn't see it?
It could have been there, Your Honor, it could have been there for a substantial period of time. It could have been there for only a minute. But the key analysis here is, and in compliance with Section 7680755, is when you have employees exactly where the substance is, and my client's testimony is that she slipped and fell on a puddle of water and that it got her wet. When they're there, isn't it for the jury to decide whether or not, if it's 10 seconds, 5 seconds, or 5 minutes, whether the conduct of Publix is reasonable in compliance with the statute? The court, as the gatekeeper, has to simply decide under the facts and circumstances whether there's evidence of constructive notice. And let's be clear, when there's employees in the area, there are cases from the 60s, 70s, and 80s, and I've cited them in my brief, the Helen Holmes and Markowitz case, and the Greenleaf case, that talk about the fact that when people have a line of sight, employees at a store, and can see us and could have seen a substance, that's circumstantial evidence. This isn't some proposition I'm making up.
Well, no, but it works better when it's a frozen thing, like frozen vegetables or ice or something that has melted. That gives you a time frame. I mean, you're sitting there saying the jury could decide that 5 seconds is enough, 10 seconds is enough. That's really what the statute says, that
it talks about reasonable...
existed for such a length of time, that in the exercise of ordinary care. So Publix needs to know within 5 seconds, 10 seconds.
Depending upon the facts of this particular case, the answer to that question is yes, and here's why. Let's just say that instead of what we're talking about here, that this slip and fall occurred over on the bread aisle. Well, what's different about a cash register aisle and a bread aisle? Well, a bread aisle, it's less frequented by customers. It's certainly less frequented by Publix employees. They're not regularly walking up and down it. They're not regularly looking at it. It's in an area of the store where you don't necessarily have to go. Those are all different from what we're talking about here today. You have a mandatory spot for customers who have to check out. They must go through it.
Let me ask you this. What was the evidence, now there's evidence that 3 employees were in a spot where that location where the slip and fall occurred was visible. Was there any evidence on whether water would be visible from where they were standing?
Yes, in fact there is. Both Mr. Ramirez testified in his deposition that himself and as well as the other Publix employee who was bagging groceries at the time, that if you're standing in that particular spot and you're looking down the aisle where that water was located, you can see it. You could be able to see it. You can see it if you had exercised reasonable diligence, which is what the trier of fact would be here to decide.
But you started this morning by agreeing that there's no evidence as to the amount of time that any substance was on the floor.
I do agree to that. I do agree to that. I do. But again, I don't believe that under these circumstances that you have to show the amount of time in order to comply with the statute. Now, I have a second argument, which I'm going to save for rebuttal because I'm getting a little close to my time, but I want to focus on this position because Your Honors are so focused on it, is that this situation is diametrically different than one such as on the bread aisle that I think, and I think you have to think of it in context like that, because if we know that constructive notice can be shown, and historically has been able to be shown, when you can show employees are in the area and they have an opportunity and a line of sight to see a substance, yet don't recognize it and don't remedy it, courts have held, the Florida Supreme Court has held, that that is evidence of constructive notice that requires resolution of a case by a jury. So even with the new statute from 2010, If, in fact, that is circumstantial evidence of constructive notice, which is all the statute requires, then the inquiry is limited solely to the amount of time or whether there's people there, whether they could see it or not. And who gets to decide that? The trier of fact.
Does the new
not the judge.
statute change the burden of proof?
I'm sorry?
Does the new statute change who has the burden of proof?
It absolutely did, Your Honor. It changed the burden of proof fundamentally. The court will recall that the statute in effect and the law in effect before 2010 under Owens versus Publix was that once the plaintiff showed that there was a substance on the floor, the burden of proof shifted to the business owner to show that they had to act, that they acted reasonable. That was it. There was no constructive notice requirement. There was no actual notice requirement. So 2010 fundamentally changed the burden of proof for a plaintiff. Fundamentally changed it. And so when you look with that statute, and I can handle this, I'm running out of time here, I'll handle this on rebuttal, is that why I believe that the facts of this case show that we've complied and comported with the statute. But secondly, is that I think that the statute, the way the language was used by the legislature, was done such as you can use the Markowitz case, which predated the statute, or the
May
Green
versus
case.
shall.
I'm sorry?
The may versus shall.
Correct. But it's actually may versus must. Yes, okay? So with that, I'll reserve my time. Thank you.
Good morning, Your Honors. May it please the Court, my name is Diane DeWolf for the appellee, Publix Supermarkets. Your Honors, I think counsel has just conceded this case. What counsel has said is that there is absolutely no evidence of how much time the substance was on the floor. There's absolutely no evidence that it was a regular occurrence, that it occurred frequently and thus was foreseeable. And there was no actual notice here. Those are the things that the statute requires. And without that, you cannot prove, this case cannot survive summary judgment.
Let me ask you about Markowitz. You know, if the statute hadn't changed, would you agree that Markowitz would suggest a result favorable to the plaintiff under the facts here?
Absolutely not, Your Honor. Markowitz is a fundamentally different case for several reasons. One, it does not involve a clear liquid. Two, it wasn't just that the employees were in the vicinity of the grape in that case. That was a negligent mode of operation case.
Well, they decided that on both grounds. They said, we reverse because you could, proceed on a mode of operation, but then they also said you could proceed on constructive knowledge. They addressed both issues specifically. not just
Exactly,
one.
exactly.
So
But
leaving aside the mode of operation, they're holding on the constructive knowledge was that there was enough there to avoid summary judgment.
Exactly. There were 3 employees, one of which was within inches of the grape, and the 3 employees were engaged in a conversation. They were chatting. There is absolutely no evidence in this case that Publix employees weren't doing exactly what they were supposed to be doing, and I submit that the vicinity is really, it's not important here. There's a fundamental disconnect with counsel's argument that employees were in the vicinity of where the liquid ultimately was, but we don't have any idea how long the liquid was there. Maybe the liquid was there for just a second. We don't have any of that evidence.
Markowitz, we don't know how long the grape was there, right?
We don't know how long the grape was there, but we do know that it was the time when all of the elderly people were getting let out of the cafeteria and they were traipsing back and forth up to their rooms with food that they shouldn't have been carrying, and there were 3 employees standing there within inches of the grape who should have known that the grape, a 3-dimensional object, which is not a clear liquid, and I think the clear liquid cases are much different than the grape cases because it's nearly undetectable. It's something that you can't see. A grape is fundamentally different. You have 3 employees standing right there, right next to the grape, engaged in a conversation, chatting.
Your ability to detect water versus your ability to detect a grape go to the weight of the evidence, or is it a factor for summary judgment? In other words, if it's visible and if they hadn't been engaged in conversation, maybe it's easier to see a grape than water, but does that go, to question for the jury as opposed to, a major factor for summary judgment, whether it's a grape or water?
No, and I don't think it does. I don't think that is a jury question. I think the clear liquid cases are all the same, and we cited several
What
of them.
if the water, well, and I'll get to the, I mean, a lot of those cases came after the statute, I was going to get to that, but as far as Markowitz, at the time of Markowitz, I'm having trouble seeing the difference between grape and water if they're visible. Just because one's, you know, if the Supreme Court, under the old statute, is saying that, look, if you're in a place where you can see a grape, you know, maybe you're in a place where you can see water too. You know, if it's not visible, then that's a different story, but if it is visible, I'm trying to see how that's not a fact question.
Well, Judge Evander, in the clear liquid cases, and they're all consistent with this, you have to show something else besides there was a clear liquid on the floor and somebody slipped. That alone, and that's all we have here, is not enough to survive a motion for summary judgment. What we have is, and Ms. Jagnanan at first said she didn't see the water, and then she said, yes, I saw it. Was it clear? Yes, it was clear, okay? The other clear liquid cases are very consistent, and they say, was there evidence of track marks? Were there footprints? Were there cart marks? Was there debris in the water? Was there
Those
any
are other
evidence?
factors. Those indicate age, just like if the grape has been stepped on a few times and all that. But let me ask you this. Do you think Markowitz is still good law with the new statute?
You know, I have to say that Markowitz, there were a lot of other things going on in Markowitz. I think it's possible that if the only thing was there was a grape on the floor and no one noticed it, I don't know that would have been enough to send it back to the jury. I don't think Markowitz has been overturned, but I think it's fundamentally different from this case.
There's been a statutory change since Markowitz.
There has been a statutory
Is there any
change since
indication
Markowitz.
from the Florida Supreme Court, one way or another, as far as, you know, how applicable Markowitz is now, given that the burden of proof has changed from the defendant to the plaintiff on that issue?
I don't think the Supreme Court has spoken as to whether Markowitz has been overturned or is still good law, but I would still say the facts of that case are fundamentally different, and there were a lot of other factors in that case that led to a jury question, which aren't present here. You know, Greenleaf is the same thing. Greenleaf was, there was evidence in that case that the employees didn't do the inspection the night before, that they hadn't checked the parking lot, they hadn't checked where the cars come through that morning. Procedures had not been followed. In the Cracker Barrel case, the other case relied on by Ms. Jagnanan, there was evidence in that case that it was frequent, that they were traipsing in and out of the kitchen all the time with these beverage pitchers, and this happened as a regular occurrence. You know, those things led to, factual questions. But the clear liquid cases, and we've cited several of them, we've cited the Brevard College case, we've cited 2 Target cases, the Publix case that we cited, the Schmitz case, all of those cases say the same thing. Having a clear liquid on the floor and someone slipping on it, which is all we have here, is not enough to create a jury question.
Let me ask you this. What's your response to the argument that on the may versus must? Because I know opposing counsels made that argument. I'm not sure the third DCA agrees with it, but what's your position on that?
My position is
that they're not limited by the 2 grounds set forth in the statute.
Well, my position is that argument's not preserved, Your Honor. That was never raised in the trial court, and in the reply brief, counsel says, yes, it was raised. We said you can argue vicinity. That is not the same thing as making a statutory construction argument and arguing the terms of the statute. Second, the statute says you can prove, you may prove constructive notice by this way or this way. It uses the word or, so it's giving you 2 choices on how to do this. Third, if vicinity is something that can be considered, fine, but vicinity of the spill, and you don't know how long the spill has been there, that's still the fundamental disconnect. You can have, there's Publix employees everywhere. They're always going to be in the vicinity of somewhere. You walk into Publix, you see employees everywhere you go. You don't have to look for them. They're everywhere. So what we don't have here is we don't have where the liquid was or how long it was there. And without that, it doesn't matter whether they're in the vicinity. That liquid could have been there for half a second.
With regard to the witness who mopped up after, the difference between his statement to his supervisor and his deposition testimony is that there was or was not anything there for him to mop up. Does that create an issue of fact regarding how long?
Completely irrelevant. Completely irrelevant, Your Honor. It doesn't matter whether there was liquid there or not. Let's say there was. We don't know how long it was there. We don't know how it got there. We don't know who put it there. We don't know how it was caused. We don't know anything about it. We certainly don't know that it's frequent. We have no evidence that it was there, that people regularly fall in front of the candy machine. And you know, counsel has tried to make this a fact-specific case. At the end of the day, there are two facts that they have relied on to say that there's an issue of material fact. And neither one of those cases, whether he mopped up or whether he didn't, that's one of the facts, makes any difference. Let's say there was water on the floor. We're back to, again, clear liquid on the floor and someone slipping in it isn't enough. Let's say he mopped something up. We had clear liquid on the floor, someone slipped in it, that's still not enough. The other factual dispute that counsel has tried to say is an issue is where Ms. Jagnanan fell. Did she fall in the aisle? These people were up and down the aisle. Ms. Jagnanan's own testimony is that she was not in the aisle. She was asked several times. This is in the record, this is in her deposition between pages 256 and 264. She was asked 3, 4, 5 times, where were you? She says, let me explain it to you. I was not in the aisle. I had turned to go into the aisle. I was walking straight ahead. I fell in front of the machine that have candies. I was not in the aisle. No, I was not in the aisle. She was in front of the end cap. She was in front of the machine that had candies in it. That's not within the viewpoint. It's not within the aisle. But even if it was, even if the liquor was in the aisle, even if that fact was in dispute, which I don't think it is, even if it was liquid in the aisle, it still doesn't matter because at the end of the day, we're still in the same place. We're still with clear liquid on the floor that someone slipped in. And without more, that is not enough to, under the facts of this case, it's not enough to survive a summary judgment. I think that's about all I have, unless you have specific questions for me.
Questions? No questions? Okay, thank you.
Thank you.
All right, you've got just a little bit less than 5 minutes.
I see that. Thank you, Your Honor. Appreciate it. Okay, let's be clear on a couple of things. The Toma versus Cracker Barrel case and the Greenleaf case, both are clear liquid substances cases. As much as Publix attorney doesn't want them to be, they are. They simply are. So in terms of whether circumstantial evidence of line of sight in the area employees involving a clear liquid is enough to overcome a motion for summary judgment, those cases clearly hold that, without question. But in terms of the statute, which I didn't get to touch on before, I mentioned earlier that the statute fundamentally changed the burden of proof that a plaintiff had to prove in the trial court in order to prevail in a slip and fall case on a transitory substance. Again, before this, it was simply there was water or something on the floor, you show that you slipped and fell, the burden shifted then to the defendant to act reasonably. 2010, after a lot of lobbying, stores like Publix and Walmart were able to convince the legislature to enact this statute to try to limit these kinds of suits, and they give us this statute. Well, what does the rules of statutory construction tell us about how to interpret this statute? The first rule is simple. The statute should be given its plain, ordinary meaning. That's it. So in this case, the statute tells us that if you're going to prove this case, you must prove that the business establishment had actual or constructive notice. So clearly the legislature knows how to use the word must. And in the exact same paragraph, they say constructive knowledge may be proven by, and they provide 2 examples.
All right, so the may could be one of these 2, or your argument is it could be one of those 2 or something else.
Exactly.
Okay, now has the third DCA and, do they seem to disagree with your argument?
It's possible that they did, Your Honor. I haven't read that opinion. But I don't know that they made the same argument that I'm making now, which is this, is that this court is required...
You're free to say if the third's wrong. So.
And I do. This court is required to construe the word may as permissive, absent one of 2 circumstances. First, that it leads to an unreasonable result. or that it leads to a result that is contrary to the legislative intent. Well, what was the legislative intent? Let's tackle that one first. The legislative intent was to change the burden of proof and shift it back and put it back on the plaintiff. So, does requiring constructive notice or actual notice be proved by the plaintiff in the manner that I'm suggesting? Employees in the area, high-traffic area, ability to look down and see it but yet don't recognize it. Does that somehow or another conflict with the legislative intent? I put it to you that it does not. I think it's in fact completely consistent.
Are there cases out there that side with you on this in terms of construing 755 as the may is either of these or something else, or this is a
Not that I'm aware of, Your
shot?
Honor.
Okay.
Not that I'm aware of. So I put to the court that if you construe the statute in the manner I'm saying, is that you must find that may is a permissive term and not a obligatory term, as the defendant has argued, then it is completely consistent with the legislative intent per the change in 2010. Secondly, the argument is, well, is it going to lead to an unreasonable result? Of course it's not. You're still putting the burden of proof on the plaintiff. The plaintiff is still obliged to come forward with evidence of constructive notice. And if that notice is in the form of employees, supervisory employees who are on aisles, busy areas, who have an obligation to clean and maintain the store like Mr. Ramirez does and has admitted, then obviously that is a manner in which constructive notice can be proved by the long history of cases, all the way from the Supreme Court, that show that constructive notice can be proved under these types of circumstances, even when it involves a clear liquid. In any event, and to conclude, I think there's material issues of fact that exist, genuine issues of material fact that exist, that preclude the entry of summary judgment in favor of Publix in this case. I think the trial judge clearly, as Judge Evander intimated, weighed the evidence, the distinction between a grape and a puddle of water. Maybe a puddle of water is a lot easier to see because it's reflecting off the light than a single grape. So whether it's three-dimensional, the size of the puddle, that's a jury who decides those kinds of things, whether something's easier to see or not. And lastly, I do believe that the construction of the statute is consistent with the express statutory language in the manner that I've posited. And I appreciate your time.
Thank you. Well argued by both sides. We will be in recess.